More than a decade ago, I did a video about steps that fathers need to take if their child's mother or the other parent, if you are the mother, will not allow you to see your child. And it's been a minute. And I feel like now is a good time to update that video because even though the legal landscape is the same for the most part, there are some different strategies that have evolved, and I just have a little bit more skin in the game. I've been practicing law a lot longer. I've employed some different strategies myself as it relates to child custody and family law cases that I handle for clients. And so my insight is just a little bit different. I have a little bit more perspective now. And so if you have not already seen that video, feel free to check down in the description box below. I'll put a link to it. And yeah, so let's just jump right into it. The first thing that you need to do, whether you have a child that's on the way, which we'll talk about in a second, or if you already have a child who is here with someone, the first thing that you need to make sure that you are fully aware of is what are the rules and the laws in your state. And every state has their own different laws. Every state has their own procedures and processes. So that is literally going to be your step one. And so figuring out what you need to do in order to establish your rights in your state is going to be really important. So for example, the state of Georgia has a whole legitimation process before you can even ask for custody if you are a father. Some other states have a similar process. Some states have a process where you only need to file a petition to establish your parental relationship with your kids. So knowing what the process is in your state is step number one, first thing you need to do. Now, if you do not know the laws in your state and you would like to easily access them, I have taken the liberty of putting together a list of all of the states and links to various resources and laws related to the states for my program called Family Court Academy. If you would like that document, it's free. I'm happy to provide it to you. Click the link down in the description box to request a copy of the PDF, and we will make sure that you get it in your inbox. All right. So step number one, know what the laws are in your state. Step number two, second thing that's important is if you have a child on the way and your baby is not here yet, it is important that you start doing what's needed to be done. That's a long way to say that sentence. Start being proactive now, right? You don't have to wait until your baby is here in order to start getting your ducks in a row. You got 9 months from the time that the baby is in the belly and maybe a little bit more. You know how that goes, right? You've got some time. So even if you just found out that someone's pregnant and you know that the two of you are not going to be together forever and you're not in a relationship now, or if your relationship is rocky and you're not really sure, now is a good time to go ahead and start setting yourself up to make sure you're not having to scramble at the last second when there's a disaster or chaos or when they're trying to block you from your child to try to figure out then what's going on. And so again, it goes back to step number one, which is making sure you know the laws in your state. Now, some states will even allow you to go ahead and file your petition to establish your parental relationship with your child before your baby is even born. So in the state of California, if you know you have a baby on the way and you know that this is going to be a crazy process and you may find yourself in a position where your child's other parent is going to be blocking you from being around your child, or they've already made statements about how, you know, they're going to raise the baby on their own or whatever the case may be. As a dad, if you're a dad watching this, then you can go ahead and file your petition to establish your parental relationship with your child now. If you're not in a state that will allow that, being educated and knowing what the laws are and what the process is, you can go ahead and have those papers filled out so that when that baby arrives on this beautiful earth, you can go ahead and file those documents. You'll have your case open, or we'll have started whatever process is necessary in your state. And that way, within a few months, you'll already be on your way to making sure that nobody has the ability to block you from being with your baby. Right. So that is the most important thing that I think a lot of times we miss. And a lot of times is you don't really realize that that's even a possibility, or that you might need to do that now, or, you know, you're hoping that you'll be able to cooperate. And in some situations that works out, in a lot, not so much. So, you know, your child's parent or soon to be parent better than I do. Right. And you know what road you might be going down. So if you know you're going to be going down that road, make sure you're ready. So the next thing is, if you do already have a child, the child is born and you need to establish your rights and you haven't done that yet, then that again, it goes hand in hand. Know what the laws are in your state, know what that process looks like. Now, a lot of times people have a misconception that just because they signed the birth certificate, that was enough to establish their parental rights. And so while that might establish that you are their father, right? And so you could take that birth certificate, for example, to the school in some states or to the doctors and things of that nature. That doesn't necessarily establish your rights in family court. That doesn't necessarily mean that you are going to be granted custody of your children. So in a lot of states, there is another step beyond that of just signing the birth certificate or the voluntary declaration of paternity, which is that paper that you sign at the hospital in some states. So when you are navigating this family court scene, right, understand that even if you have already signed the birth certificate, there's a high chance that you also have to fulfill a different process, which is establishing your rights in the family court. So then you can ask the family court to establish custody and visitation orders, which brings me to the next step, which is after you've established your case, after you have opened your case in family court, the next thing you're going to need to do is make sure that you are requesting that the court issue custody and visitation orders. Just opening the case is not going to be enough to establish the custody and visitation orders. You need to specifically file whatever needs to be filed in your state, whether it's called a motion, whether it's called request for orders, whether it's called request for custody. Again, going back to making sure you know what the rules and the procedures are, you'll know what you need to file the appropriate paperwork so that you can specifically request that the court grant you custody of your child or visitation rights for your child. And in that request, you're going to need to show, and this is pretty much the standard everywhere, you're going to need to show that whatever custody arrangements you're requesting are in the best interest of your child. So why should you have custody of your child? Besides the fact that you're their biological parent, why should you have custody? Why should you have visitation? I have other videos that go deeper into, the way you can win custody of your child or the best way to get the court to grant you visitation and things of that nature. But again, you need to ask the court to issue custody and visitation orders. That will usually come with the process of a court hearing. And at that time, the court will likely issue orders. The court may also require you to go to mediation, which is required in some states before the court will even issue orders. But again, this is all about getting the process started so that you're not just sitting here having to rely on the other parent to give you time with your child. So for those of you who already have custody and visitation orders in place and the other parent is just choosing not to follow those orders, what you have to do to make sure that you can see your child is enforce those orders. Now, what that is going to look like is, again, going to depend on what state you are in. So in some states, you may not have a choice but to file a contempt proceeding. That may be what they call it. A contempt proceeding is like a semi-criminal, semi-family court proceeding, civil proceeding, where they hold the other party accountable for violating a court order. I'm sure you see it on TV, right? You see the judge say, I'm going to hold you in contempt. That's what contempt is. Basically, the court issued an order, somebody's not following it, and somebody's not happy about it, usually the judge. So if that's what you need to file, then file it. In some states, you might just need to enforce the orders, file a request or a motion with the court to inform the court that the other party is not following the orders that were issued. Now, this is a step that I feel like a lot of people miss. So oftentimes, I have people come to me and they say, oh man, my child's other parent, they won't allow me to see my kid. I haven't seen my kid in 2, 3, 4, 5 months. In some cases, I've handled cases where my clients have not seen their children in years because the other parent was blocking them in various ways, right? People get creative. They move, they disappear, they block you on all electronic communication forms. All kinds of things happen. But either way, the reality is that one of the biggest mistakes that I see people make is when the other parent is blocking them from being in a relationship with their child, from seeing their child, and they already have orders in place. They don't do anything about it. They don't file anything. They just hope the other parent is going to come around. They're not. They're probably not. And maybe they will, but how long is that going to take? How long are you going to wait for that? And so I'd say that one of the best things that you can do for you and your child is as soon as, and I mean, you can have some grace. You can give them, a visit or two to miss because they're being difficult or they got an attitude or they said, you can't come for this reason or that reason or whatever. But after that, I wouldn't give them no more grace. Go ahead and file whatever you need to file so that you can get your hearing date on calendar and you can let the court know, hey, you issued these orders and you said that I get to see my kids on, every weekend or every other weekend or according to this 50-50 schedule. But other parent here is not following it and doesn't believe that your orders are important, Your Honor. And doing that is putting the court on notice, because the reality is a lot of times people are like, well, what's the point of having court orders if they don't have to follow them? They do have to follow them. The problem is we forget that the courts don't know if they're following them or not, right? The judges have a whole lot of cases. And so unless you go to the court and tell the judge, hey, you issued an order and she's not following it or he's not following it, they're not going to know, which means there's no real way to fully enforce your orders unless the law enforcement officers in your area are going to do that, which that's a whole nother conversation for another day. But again, taking action and making sure that you file whatever needs to file to put the court on notice that the other parent is violating the orders, that is going to be another important step for you to make sure that you can maintain that relationship, and doing it sooner rather than later. Even if you file it now and the other parent comes around, right? Or even if you file it now and your hearing date is 2 or 3 months out, you have time to try to get them to cooperate and things of that nature. And they still don't, you have the hearing date on calendar, right? If they start cooperating and you decide you don't want to go back in front of the judge, cool. You can ask the court to take your hearing off calendar or tell them that you've resolved it. So again, putting that action into place so that you can enforce your rights is really, really important. Before you have a court hearing, a lot of courts will require you to go to mediation first, or participating in voluntary mediation may be a good option for you. So what I like to tell people is that the reality is you don't never really want the judge to make the decision about what's going to happen with you and your kids and your family on your behalf. You just don't, because 9 times out of 10, nobody's going to be happy walking out of that courtroom. They might give one parent this thing and the other parent that thing and try to meet in the middle for the other thing. Or they might give the other parent what they're asking for and don't even consider what you were requesting, or whatever the case may be. Judges don't know you. They don't know your kids. All they know is whatever is on paper and whatever is presented to them. And so once they're reviewing that stuff that was presented to them, then they're going to make a decision about what's going to happen with your life. And I mean, if you don't have a choice, right? If you've tried mediating, if you've tried cooperation, if you've tried all these things and it doesn't work, cool. That's what the court system is for. But if you can avoid a judge making the decision for you, that's what I'm going to do. And I'd say about 75% of my cases actually settle because we ultimately are able to negotiate and come to an agreement that is reasonable and is decent. Maybe not 100% satisfactory, but decent enough or doable enough for both parties. And that oftentimes is putting you in a better position than if you had just chosen to let the judge decide. A lot of people are just like, I'll see you in court. I'll see you in court just because of ego. And the reality is you might not really want to see them in court because you don't know what this judge is going to do. So if mediation is an option, I definitely participate in the mandatory mediation that's required if your court requires it. But even if not, propose mediation for the other party and propose that in writing, because then if they turn it down, that's something else that you can tell the court to let them know that this person is just being difficult for the sake of being difficult. And so if you can mediate your case, a mediator who is a third party, specifically one who is experienced or specializes in family law cases, can be super, super helpful, right? Because they're able to provide some perspective and insight that you or the other party, will hear from a neutral person that you may not have considered otherwise. And so a lot of times I'll have, parties come to me who want to work with me, and they ultimately decide that they would like me to be their mediator because I can have conversations with them. I can let them know what the laws are in their state. They can really have some time to consider, the benefits of this agreement versus that, and the benefits of resolving your case together instead of going to court. and we're able to get things handled without them ever seeing a judge. So don't knock the mediation process before trying it if you can get the other party to participate. If not, then it is what it is. Another thing that's really important is when you are going through a family court case, if you can hire a lawyer that specializes in family court, a good lawyer, not just anybody, which another video, another day. But if you can hire a good family lawyer who can help you through this process, who can help you put your case together and help you get everything in order so that you can present it to the court in a way that's going to be persuasive, that's the route I'm going to tell you to go. If you can only afford to do a consultation, or if you're just over lawyers in general, advocating on your behalf and you think that you can advocate better, which is the case in some cases, then at minimum, if you can consult with an attorney just to get the laws and the rules and the procedure so that you at least have that. A good attorney who offers paid consultations, for example, mine, right? My paid consultations, I literally will walk you through step by step of what needs to happen. I will send you the forms. I'll send you the instructions. And in some cases, I review the documents to make sure that you've done them the right way before you file them with the court. And then I consult on the back end. I give you the talking points for your hearing. Make sure you know how to present your case, the objections you can make, all of these things, right? So consulting with a professional who does this is always going to be your best bet, even if you decide that you're going to represent yourself. It's less costly than hiring a lawyer on your own, but still allows you to have that layer of security to know that you at least got the right information. If you're open to that, I would definitely consider it. If you are looking for resources or, free legal help or someone to assist you on the back end, almost every court in every state has some type of self-help services now, where people will help you with your paperwork at the courthouse or through an organization or something affiliated with the courthouse. There are oftentimes some nonprofit organizations who will offer pro bono services, meaning you don't have to pay for them and they'll assist you. And then you also have attorneys who can, again, consult you on the back end, offer limited scope services where they're not actually representing you, but they can help you, with your paperwork and stuff. I'm going to go through a few mistakes that I believe are common that oftentimes fathers or the parent, who's being denied custody of the child or parenting time with the child make when it comes to this type of situation. So mistake number one, and I know I touched on this earlier, is waiting too long. Again, don't give the other parent that much grace. The moment that you start to see that they're not going to cooperate, it doesn't matter how hard you try. It doesn't matter how much you beg and plead and tell them you need to do what's best for our kid. If they're not going to do it, then you need to take action now. Be proactive. If you got that baby on the way and you know that this is about to be a battle, get that battle started now so that you don't have to wait till your child's 3 or 4 to be able to spend time with them or whatever. Don't wait too long. The next thing that I think a lot of times people miss is they act emotionally and not strategically. And one thing that I tell people all the time is that family law is literally, I'm not going to call it a game because it ain't a game, right? But it's literally like who can present the best case, who has the best strategy. And one thing that you have to remember is that everyone in the family law case is usually very emotional about some part of it. And so your emotions are going to naturally be running high. So one, you need to make sure that you have support for that, whether that's a therapist, whether that's a trusted friend, whatever that looks like. Make sure that you got your emotions in check. And then also you need to think strategically. And you have to respond and act in accordance with what you know is best for your child and with the focus of getting things done. Focus on the end game, right? So yes, they want you to argue with them right now. Is that going to be beneficial for your case? Or is responding as the cooperative parent who's trying to be reasonable going to be the thing that helps your case? Do the reasonable thing, right? If they want you to violate the orders or they're doing all of these things, is violating the order going to help? Probably not. It might actually get you in trouble, right? So follow your orders, even if you don't agree with them. Make sure that you do not allow them to trigger you. And this is a big thing. People will intentionally do things say things in order to try to trigger you to do something that is going to jeopardize everything that you are fighting for. Those calls, those messages, those texts, the gestures, the facial expressions, all of those things that they're doing to try to trigger you, to get you to cross that line that they know, because they know you, maybe. They probably know you, at least a little bit. Don't fall for it. And I always tell people, don't take the bait. They're going to try to bait you, and you got to learn, that's the bait. Nope, not doing it. So you always, again, have to remember, when you are in the midst of a family law case, everything is strategic. Cases are won based on strategy. Let that person act a fool for 6 months straight while you're getting all your stuff together, and document everything so that by the time you're in trial, you can literally lay it out for the court. The other party violated on this date, 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 this phone call, this date, this date. I promise you, if you can lay it out and present it in a way that the court can actually listen to it, and I've won a lot of cases like this. Judges get tired of hearing about violations after time number 5 or 6. And usually in my cases, I have about 30 violations. So if you've been, 60 days in, you can't see your kid, or X amount of times you've tried and you've tried and you've tried and you've tried, and you've documented that and you present it right, that is how you are going to win. And so again, strategy over emotions. Speaking of documenting, not documenting is a big mistake. And it's a mistake that a lot of times people make, usually out of frustration because they're tired, right? So after the 10th phone call and the 10th time you tried to reach your child or showed up for a visit, you just don't keep track anymore. A lot of times people come and say, I haven't seen my child in 3 months. Well, when's the last time you tried? I don't know, so-and-so weeks ago. You need to have the details. Keep a journal. Keep a written list of the dates that you've called and they've gone unanswered, the dates that you called and they hung up in your face, the times that you showed up for your visit and they didn't show up, or they said, no, they can't come. Show up every time. Document every time. And document every effort that you make to try to be in your child's life, so that in the event you have to go before a judge, you will know down to the hour. I showed up on January 22nd at 4 p.m. Our visits were supposed to start at 4:15. I waited until 4:42. She didn't show up, or he showed up, but he was arguing with me in the parking lot. We had this witness and this witness. I got their names. I got their phone numbers. We can provide that testimony, whatever it is, right? I called at 3:30 on the dot on this day for our scheduled phone call. They didn't answer. I sent a message at 3:33 and said, hey, I tried to call at 3:30 and you didn't answer. Please have my child call me back. To date, I still haven't received a phone call. Anything that you can do to document your efforts and show the court, I'm doing everything that I can, and now I need you to do something, is again how you're going to win your case. A lot of times people come in and say, she don't ever let me see my kid. And then you ask, well, when's the last time you tried? Or how often did you try? Or what specifically did you do? And if your answer is, well, I'm not sure. If your answer isn't definite, you need to document better. That's how we win. So I have a co-parenting journal. Again, I'll put the link to that below. You can have that. It's free. It's a journal that you can use to literally, you can print it out and write everything when it comes to your co-parenting and how it is impacting you, your child, where the violations are, so that you can always have somewhere to keep track. But even if you don't use that, use a notebook. Use it in your car. Keep one in your house. Keep one in your purse or in your, somewhere near, so that you can always just jot it down. Open a note in your phone, right? We got technology these days. Open a Samsung note or an iPhone note or whatever they call it, and just add to it. Just call it custody. And then just add whatever the thoughts are about this day. You tried this on this day. She said that on that day. This is the day that she threatened me. This is the day she told me she was going to make sure my child was brainwashed. This is the day that I, didn't get to see my child. Document all of it so that when you have to go back and put it in a format so that the judge can see it, or if you have to hand it over to an attorney, it'll be so organized and it'll make your life so easy, and it'll make your case so much more convincing. And another thing that I think you need to do, and that a lot of people mess up on, I need you to have a little bit more faith. I need you to not assume that the court is going to side with the mom. That is not always the case. And a lot of times you lose your cases because you don't never believed in it to begin with. You got to walk in there with confidence and know that you are a good parent for your child, that your child needs you, that you have done everything that you can to be a positive person in their life, to make sure that they have everything that they need and that you operate in their best interest and that you are trying your best to be involved. And again, having that documentation, that is what you need to do. You got to be confident, and don't give the court an option to side with mom. Stop allowing the courts or whoever to convince you that you don't deserve custody of your child and that you're automatically going to lose because you're a dad. That is not always the case. And it may take a few rounds. In some cases, you may have to go 2, 3, 4 times. But you know what? Walk in there every single time with your head held high. This is your child too. And I think that a lot of times that's what y'all forget, specifically fathers. I don't want y'all to forget that, because your child don't forget it. That is your baby, and you gotta move like that's your baby. That's your child. And don't let nobody get in the way of that. Not even yourself. All right. I think that is enough for this video. And if you have any questions, feel free to comment down below. I will get to them as soon as I can. If you have any other topics you'd like me to talk about, again, comment below. I'm always open to suggestions and creating content that you need. But those of you who are new around here, my name is Marissa V. Grayson. I'm a family law attorney, mediator, and co-parent coach. And this is what I do. And I like to share it with you so that you can do it too. I'll see you on the next one.